When India became a sovereign democratic republic, the first thing that we did was to shake off the British crown. Pandit Nehru, being the gentleman he was, referred the matter to the Attorney General. And Setalvaj's opinion was absolutely unequivocal. There's no question of the president being a parallel source of power. If the president is satisfied that no inquiry is required to remove a civil servant because of reasons of security of state, such person can be removed without inquiry. Now the question was,
कोलकाता स्थित नेशनल यूनिवर्सिटी ऑफ ज्यूरिडिकल साइंसेज NUJS में 7वां श्री M.K नंब्यार मेमोरियल लेक्चर आयोजित किया गया। इस अवसर पर फॉर्मर जज ऑफ सुप्रीम कोर्ट ऑफ इंडिया जस्टिस रोहिंटन फली नरीमन ने राज्यपाल की भूमिका, केंद्र का प्रहरी या राज्य का सार्थक प्रमुख विषय पर व्याख्यान दिया। कार्यक्रम की अध्यक्षता फॉर्मर वाइस चांसलर ऑफ नेशनल लॉ यूनिवर्सिटी भोपाल प्रोफेसर विजयकुमार ने की। NUJS के वाइस चांसलर प्रोफेसर डॉक्टर निर्मल कांति चक्रवर्ती ने अतिथियों और प्रतिभागियों का स्वागत करते हुए कहा कि ये व्याख्यान संविधान और शासन पर गंभीर चर्चा का मंच है। श्री M.K नंब्यार की स्मृति में आयोजित ये व्याख्यान श्रृंखला देश के प्रमुख न्यायविदों और संवैधानिक विशेषज्ञों के विचार साझा करने का अवसर देती है। इस वर्ष का कार्यक्रम भी विधि विशेषज्ञों, विद्यार्थियों और नीति निर्माताओं की सक्रिय भागीदारी का गवाह बना।
जस्टिस नरिमान যেভাবে বললেন একদম কনস্টিটিউশনাল প্রভিশন আছে, সেখানে যা ঘটছে অনেক কিছুই যেটা কনস্টিটিউশনের বাইরে, সেটা তামিলনাড়ুর উদাহরণ দিলেন যে এরকম 10টা বিল আমি আমার ইচ্ছা মতো পাঠিয়ে দিলাম, যেটা পাঠানোর কথা নয়। এইভাবে মিসইউজ অফ পাওয়ার কিছু একটা করা উচিত, যেখানে আমাদের কনস্টিটিউশনের কনভেনশন ডেভেলপ করা উচিত। সেটা উনি বলছেন হয়তো পরবর্তীকালে এইসব অভিজ্ঞতা থেকে আবার অন্য পলিটিক্যাল পার্টি এলে হয়তো কনভেনশন হতে পারে বা কনস্টিটিউশন অ্যামেন্ডমেন্ট করা খুব অসুবিধা, অনেক ক্ষেত্রেই থার্ড মেজরিটি হয় না, সেক্ষেত্রে কনভেনশন করার কথা বলছেন যদি ওটা হয়। কিন্তু কিছু ক্ষেত্রে যেটা আমাদের কনস্টিটিউশনের যে ম্যান্ডেট সেটা মানা হচ্ছে না, aberration হচ্ছে, সেটা মোটামুটি উনি
was only one as head of the state for the entire union, whereas in the states the governor plays two important roles. One, he is accountable for all his actions to the center, to the president directly, and again as the head of the state within the state concern, he has to perform his obligations through the provisions of the constitution. He has been asked to follow the advice of the Council of Ministers. We don't even call that as cabinet. The language used in the constitution is Council of Ministers. So he has to abide by the decision of the Council of Ministers in the discharge of his functions. In the discharge of his powers, he may have certain authority, which he can very well do. And I think the Supreme Court has also, the judge has referred to one judgment, right? Madhya Pradesh Special Police Establishment versus State of Madhya Pradesh in 2005, that there is an exceptional circumstances when the Council of Ministers or the cabinet failed to give the approval for prosecution, right? So therefore, ultimately the court has to endorse that it was a right decision. But the fact remains that the governor has performed right constitutional obligation in a given instance. So therefore, it is left to the governor to choose what is right and what is wrong, and he is always caught between these ruptures between the center and the states. I think that we should avoid, and that is a place where we are talking about constitutional conventions. Good practices must evolve, right? Then only I think the constitution can deliver better things.
Vice Chancellor Chakrabarti, Professor Vijayakumar, fellow students, ladies and gentlemen. When India became a sovereign democratic republic, the first thing that we did was to shake off the British crown, which was a hereditary monarchy. And instead of a hereditary monarch as head of state, we had an elected president as head of state. One would have thought that the governor as head of state of one of the states which comprise India would also follow suit and be a microcosm of exactly what the president is at the center. But it was not to be. Interestingly, the president as head of state is a very, very carefully guarded person. First and foremost, under our constitution, as you just heard, he is the embodiment of the executive power. He is also the commander-in-chief of all the forces. This is also interesting under Article 53. Under Article 54, the founding fathers went out of their way to see that not only did an indirect election take place through the members of parliament, because as you know, the Lok Sabha is the representative of the people as a whole, and the Rajya Sabha consists of representatives from the state.
जस्टिस रोहिंटन फली नरीमान ने राज्यपाल की संवैधानिक भूमिका पर दी व्याख्या। उन्होंने बताया कि भारत के राष्ट्रपति को संसद के माध्यम से चुनाव द्वारा चुना जाता है, उनका कार्यकाल 5 साल का होता है और केवल इम्पीचमेंट के जरिए हटाया जा सकता है। राष्ट्रपति का शपथ पत्र संविधान की रक्षा और पूरे देश के लोगों की भलाई सुनिश्चित करने के लिए है। इसके विपरीत राज्यपाल राष्ट्रपति द्वारा नियुक्त किए जाते हैं और उन्हें प्लेजर ऑफ द प्रेसिडेंट के तहत कभी भी हटाया जा सकता है। हालांकि राज्यपाल का शपथ पत्र राष्ट्रपति जैसा ही होता है, लेकिन उनकी नियुक्ति पूरी तरह केंद्र के नियंत्रण में रहती है। जस्टिस नरीमन ने कहा कि इस अंतर के कारण राष्ट्रपति और राज्यपाल के पदों में स्वतंत्रता और सुरक्षा का बड़ा फर्क है। उन्होंने 2010 के शिकल केस का हवाला देते हुए बताया कि सुप्रीम कोर्ट ने ये सुनिश्चित किया कि राज्यपाल को बिना कारण अचानक हटाया न जा सके।
Under Article 56, the term of office of the president is 5 years. And importantly, he can only be removed from office by way of impeachment, which is an extremely difficult process. And impeachment for what? For violating any provision of the Constitution. His oath, in fact, under Article 60, makes it clear that he has to abide by the Constitution and that he would seek to see that the welfare of the people as a whole is adhered to. Now, with these provisions for the president, why was there something different for the governors? In fact, it was so different that the difference becomes stark when I now compare Articles 52 onwards with Articles 153 onwards, which otherwise parallel what happens so far as governors as heads of state are concerned. Under 153, there shall be governors of states. There can be more than one or more states of which there can be governors and vice versa. And extremely importantly, the point of departure comes with Article 154, 155 and 156. Because the governor now is appointed by the president. No election. There was an article, I think 131, draft article in the Constitution, which mooted elections for governors. But somehow or the other was shelved because the founding fathers felt at that point of time that there might be a clash between an elected governor and an elected prime minister on the other end. So,
सुप्रीम कोर्ट ने ये स्पष्ट किया कि राज्यपाल राष्ट्रपति की इच्छा प्लेजर ऑफ द प्रेसिडेंट पर नियुक्त होते हैं, लेकिन उनका अचानक हटाया जाना अब बिना कारण नहीं हो सकता। अदालत ने कहा कि राज्यपाल का पद संवैधानिक रूप से महत्वपूर्ण है क्योंकि वो राज्य के लोगों की भलाई और संविधान की रक्षा के लिए जिम्मेदार होता है और केंद्र और राज्य के बीच एक महत्वपूर्ण लिंक होता है। पूर्व में जैसे नागरिक अधिकारी या मंत्री केवल सरकार का भरोसा खोने पर हटाए जा सकते थे, राज्यपाल को भी बिना कारण हटाना संभव था। 2010 के निर्णय में अदालत ने स्पष्ट किया कि अगर किसी राज्यपाल को हटाना हो तो उसके लिए सकारात्मक और न्याय संगत कारण होना चाहिए। ये कारण सीधे राज्यपाल को दिखाने की आवश्यकता नहीं है, बल्कि कोर्ट को दिखाना होगा। अदालत ने यह भी चर्चा की कि राष्ट्रपति और राज्यपाल दोनों का संवैधानिक शपथ पत्र समान है, लेकिन राष्ट्रपति का चुनाव और हटाने की प्रक्रिया बहुत सुरक्षित है। राज्यपाल के मामले में अब जुडिशियल रिव्यू के तहत ये सुनिश्चित किया गया है कि उनकी हटाई जाने की प्रक्रिया न्याय संगत और गैर अनियमित हो। इस फैसले ने राज्यपाल के पद को संवैधानिक रूप से सुरक्षित बनाने में महत्वपूर्ण भूमिका निभाई और केंद्र तथा राज्य के बीच शक्ति संतुलन बनाए रखने में मदद की।
Given this fundamental dichotomy and given the fact that he could be fired and that this state of affairs continued for 60 years, we had a constitution bench judgment in Shingal's case in 2010, which at least remedied the firing part. PILs were filed before the Supreme Court because governors of 4 states had been summarily removed by the center. Even though the matter had become academic or moot, so to speak, fortunately, in view of the importance of the questions involved, the Constitution bench took up the matter. And when it took up the matter, it delved into the doctrine of pleasure as we know it in our Constitution in great detail. It first spoke of persons who were appointed not by the doctrine of pleasure at all, but purely by the Constitution and removable again only by the Constitution. If you remember, I had told you that the President was elected and could only be impeached. Impeachment became so difficult because under Article 61, first one of the 2 houses of Parliament would have to prefer a charge against the President. That would have to be done by a minimum of 25% of the entire strength of the House, not members present and voting, mind you, entire strength. 14 days notice was given to him. And then the charge preferred had actually to be carried by 2/3 of the entirety of that House, whichever it be, Lok Sabha or Rajya Sabha. Finally, the other House would then investigate the charge. And if again by a 2/3 majority of the entire strength of that House found that the charge was preferred, the President was impeached and had to be removed. This is again in stark contrast with what would happen to, let us say, Supreme Court judges. Under Article 124(4), a Supreme Court judge can also be removed only by impeachment. But the process is very different. There, so long as you have a majority of 2/3 of those present and voting in a House which at least has half its strength, the judge gets impeached.